So what I would like us to consider now is the role of judicial precedent and how that operates within the system of the court structure, and in particular the hierarchy of the courts. So our learning objectives in this lecture is you'll be able to understand how judicial precedent operates, which is our lower level learning objective. You'll be able to have an understanding and explain how judicial precedent operates by the end of this lecture. You'll then be able to make an assessment on the role of the court hierarchy in judicial precedent, so how judicial precedent operates within the context of that court hierarchy, you can make an assessment upon. And then you'll be able to evaluate the impact of the Human Rights Act 1998 on judicial precedent. So we really want you to consider not only the role of judicial precedent, the way it works, but also the changes that has been made by the impact of the Human Rights Act upon judicial precedent. So how we're going to achieve these learning objectives then is, first of all, we will look at exactly what is judicial precedent. What do we mean by the phrase? We'll then look at the elements of judicial precedent, so we'll break it down and we'll look at it from a conceptual point of view. We will analyse each element of judicial precedent, and then we'll look at its operation, in particular at the Supreme Court and the Court of Appeal, and how the judiciary has to follow the precedents that are set down by the Supreme Court and the Court of Appeal. So our starting point then is really a definition of what we mean by precedent, and I would like you to think about the term precedent in a wider sense, so outside of the role of the judiciary. In everyday life, how does precedent occur? And a dictionary definition really speaks about it being an earlier event or an action that is regarded as an example or as a guide to be considered in subsequent similar circumstances in a sort of later event. So a precedent occurs in all areas of life. Pause here, reflect, think for yourself. Can you think of anything in your life where you've acted on the basis of someone else's precedent? A very typical example is how parents establish precedent when dealing with siblings, when dealing with their children. You may well be a parent, or you may well have siblings, or you may well have older siblings or younger siblings. And generally the parent will set down rules, set down guidance in relation to the first sibling, which is then followed in practice to the second and the third siblings. There may be an element of discretion in the way that it's applied. So by way of example, let's think of your time to go to bed, a bedtime. Let's say as a 12-year-old, a bedtime is set at 9 p.m. at night, so you can get up in the morning for school. The younger sibling comes along, and at the age of 12, that sibling will be going to bed at 9 p.m, quite simply because their older sibling did. If that child was, the second child was sent to bed at 8 p.m. at the age of 12, or even going beyond at 13, I'm pretty sure that child will be claiming to their parents, this is unfair because my older brother or sister went to bed at a particular time, went to bed at 9 p.m. rather than 8 p.m. And so they're appealing then to the parents of an element of unfairness, that they're appealing essentially precedent, that the parent needs to follow the precedent that they set in the context of the older child, and so therefore they should apply the same rule to the younger child. And we see this in all areas of life where precedents are set, and it introduces an element of fairness. So essentially you lay down a way of behaving in your interactions with others, and then it would only be fair and natural for that way of behaviour to be applied to the next person you deal with, whether that be in the context of a parent, child, or other areas of life. So we can see how precedent occurs in all areas of life, and none more so than precedent occurs in the same manner in the judiciary, because quite simply We need an element of consistency. We need an element of fairness. So the judiciary do not want to be criticised as being unfair by dealing with a later case in a different manner than they deal with in a previous case. So judicial precedent then, what we see is developed through case law. It is particularly common to the common law jurisdictions, and it's developed through the way case law operates. An Oxford Dictionary definition again of judicial precedent speaks about the law as established by the outcome of former cases. So you'll find a previous case, and the case in front of you it has similar circumstances, and it could be the same area of law, and then it would be expected that that particular case follows the reasoning in the previous case. So in order to do this, we need a system of law reports. We need to be able to find previous case law, and there is a system of law reports which particularly stem from the Supreme Court, or formerly the House of Lords, the Court of Appeal, and the High Court. And we find the law reports now on databases. It never used to be that way. A lawyer or a student would have to go into a law library to find encyclopedia type books full of law reports. However, we can quite simply find them now through databases. And so there is a system of law reporting in order for us to find these previous cases, to find the way that the judiciary has acted in their previous cases. The Court of Appeal stated regarding this principle that it serves the interests of legal certainty. The needs of litigants and their advisors simply need to know where they stand. It's not served if a lower court is free to create a conflict of authority by declining to follow the relevant decision of a higher court. So there's an element of legal certainty there. We need to know where we stand, and our litigants, advisors, solicitors, and so on need to know where we stand. So how this operates then, the elements of judicial precedent, and what we see that it is examined in the context of the court hierarchy. So cast your mind back to the way that the court hierarchy works, and quite simply vertical precedent is the case that lower courts are bound to follow the previous decisions of high courts. That's known as vertical precedent. And then there are specific rules which we're going to go into where courts on the same level, so Supreme Court following its own decisions, or Court of Appeal following its own decisions, there are specific rules that are being applied that allows courts on the same level to depart from previous precedent. It's known as horizontal precedent when that's applied, when they follow their previous decisions, and then we're looking at the exceptions, or we're going to look at the exceptions as to when the court is allowed to depart from a previous decision. So some terms you need to be aware of in the context of legal precedent. The binding nature of legal precedent is known by the Latin term stare decisis, which quite simply means let the decision stand. So it's really important that you think about these starting points before you even go on to discuss the elements of judicial precedent. So determine these starting points, these terms. Stare decisis means let the decision stand. Ratio decidendi, we need to look for the commonly shortened to ratio. We need to look for the ratio decidendi when reading a case, and that is the reason for the decision, which is based upon the law and based upon the particular set of circumstances. A particular problem is when a judge gives a decision is that they do not actually state this is the ratio, and quite often we look to later cases to see how the ratio operates in a previous case, and how judges interpret in a later case what the previous ratio was, and there can be an element of discretion there and an element of differences between the way cases are read. We also have the obiter dicta, which quite simply means things that are said by the way. So you will get in cases a judgment that talks about the law that may not necessarily be relevant to the particular case at hand, but talks about the way that the law has developed, and and it doesn't form part of the ratio, but it's classed as the obiter dicta. And in that particular case, those obiter dictas might well be persuasive on later cases, highly persuasive on later cases, but there is not a duty to follow obiter dicta comments on the following cases. They are classed as things that are said by the way. It's important that you know what distinguishing means. So it's a main device for avoiding binding precedent. It essentially means that the legal reasoning of a precedent in a previous case may not wholly apply due to substantial different facts between the two cases. So this is a way that the judiciary can recognise there is a previous ratio in a previous case. However, they may well say, well, actually this does not apply in this case because there are differences. A particular problem with that is when you get two cases, a later case and an earlier case, by its very nature there are going to be differences. You're never going to get a 100% identical case from one case to the next. And so if we're looking at judicial creativity, a judge can quite simply distinguish a following case if they don't like the previous decision of another case. And I would like you to think about that when you're reading your cases, that when the judiciary are distinguishing previous cases, are they actually distinguishing the previous case, or are they quite simply trying to avoid it by claiming that they're distinguishing it? Because you're not going to get two cases that are 100% identical. So that's a problem that we have for legal precedent, and particularly the duty that a judge has in following a previous case, that they could distinguish it. Then we have persuasive precedents, and these are precedents that are generally established by other courts that are not binding, however they are highly persuasive. So that it might well be a higher court likes the decision of a lower court. They like the argument, so a lawyer might say that this is a persuasive precedent. It could be a decision of the Privy Council, which we did in our last lecture. The Privy Council are the final court of appeal for some Commonwealth countries, and so those decisions are actually highly persuasive because quite often the judiciary that sit on the Privy Council are the same people who sit upon the Supreme Court. And so it can be said when we look at a Privy Council case that we know how the Supreme Court is going to decide, or it could be argued, so therefore they become highly persuasive, the judgments of the Privy Council. You could then have Scottish or Northern Ireland courts, and you could also have persuasive precedents from other common law jurisdictions. So Canada, Australia, for instance, may well have an area of law that they've developed that works better than what we have in our domestic situation, and so therefore the judiciary might look at that, or it might be brought to their attention by the lawyer concerned that, look, we have an element of law that has developed here, so under contract law, tort law, that actually works better in these circumstances. However, this is an Australian case, and so therefore the judiciary will look at that as being persuasive at the matters at hand, but they're not under a duty to follow it. Problem for lawyers and for us as law students is that when judges reach a particular decision, they very rarely use these phrases. So it must be, therefore, the cases as you read them must be analysed with some depth to identify how precedent works within the case. So how does it work in action then? Well, the Supreme Court, the decisions of the Supreme Court, and as was previously the House of Lords, they bind all lower courts. For some 100 years, the law lords also felt themselves bound by their own previous decisions, which changed with the practice statement in 1966 that you need to be aware of. In Austin against Southern London Borough Council, Lord Hope said, who all the court agreed, that as far as the Supreme Court went, the practice statement applied had as much effect in the Supreme Court as it did before in the House of Lords. So they followed suit in that respect. So what is the practice statement then? When do the House of Lords or the Supreme Court feel that they can depart from their own previous decisions? Well, it says there in the practice statement, their lordships nevertheless recognise that too rigid adherence to precedent may lead to injustice in a particular case, and also unduly restrict the proper development of law. So they recognise there should be a development of law, they recognise society evolves, and whilst the law may have a particular answer 100 years ago, that particular answer may not apply in the modern context. It says, so they propose therefore to modify the present practice, that practice of sticking to previous precedent, and whilst treating, and this is the important point to note, whilst treating former decisions of this House as normally binding, so that's the starting point, that they still treat the decisions of this House, or in the context of today the Supreme Court, as normally binding, to depart from a decision when it appears right to do so. So they will depart from a decision when it appears right to do so. So it's important to note that this is not a new rule. This is quite simply an exception to the rule that the decisions of the House are normally binding. So that is still the rule. The rule hasn't changed. The decisions are normally binding. This is now an exception that's been introduced to depart from that decision. And it then goes on to state this announcement is not intended to affect the use of precedent elsewhere than in this House. So this doesn't apply in the Court of Appeal. It applies as far as the House of Lords goes, and now the Supreme Court. So it's an exception to the rule that former decisions are normally binding upon the House. So I'd like you to reflect and think about how society can change, whether that's economically, technologically, socially or politically. Maybe there are advances that have taken place in society throughout the 20th and 21st centuries. And with that example in mind, why do you think the House of Lords would need to introduce this exception that it does not normally bind itself? So there may be advances in society. Start thinking about some advances in society that have taken place and consider how and why the House of Lords would have introduced this exception. And we're going to look at some examples now. So these are some of the main cases that I would like you to have a look at. Have a read of these cases in your own time. Nuller against the DPP was an interesting case. It was the first time after the publication of the practice statement, so we can see some time had elapsed, that it is rarely being used, because this was 1973. And in that case the House of Lords were invited to overrule a decision in a criminal case, which was the controversial decision of Shaw against DPP. And in Shaw against DPP, what we had happen was a case where the appellant had published what was known as a ladies' directory, which was essentially contact details for prostitutes, and they were charged with a conviction of conspiracy to corrupt public morals, living on the earnings of prostitution, which was an offence under the Obscene Publications Act. The particular problem that this idea of conspiracy to corrupt public morals was not really an offence as such, other than offences from hundreds of years ago under what was known as the Star Chamber, which was a particularly harsh and onerous application of the law in history. However, it was held on that case that conspiracy to corrupt public morals was held. The appeal was dismissed. A particular problem in that was Lord Reid was not problem. I say quite an interesting dissenting opinion. Was Lord Reid saying that essentially that the law should not go as far as to punish immoral acts. In this case, that he saw no problem with the ladies' directory as contravening criminal law in that particular sense. However, when we got to Nuller against DPP, which was a similar set of circumstances, but the magazine concerned was concerned with homosexuals seeking to meet like-minded individuals to engage in sexual practices. So it was a magazine much on the same sense of Shaw against DPP, but in this case, where Shaw against the DPP concerned prostitutes, Nuller against the DPP concerned a homosexual magazine. And Lord Reid, who had dissented in Shaw against DPP on the decision, he actually was the lead judgment in Nuller against DPP, so they were invited to make use of the practice statement. And he actually stated, he says, I dissented in Shaw's case. He says, on reconsideration, I still think the decision was wrong. He says, I see no reason to alter anything which I said in that speech. But it does not follow that I should now support a motion to reconsider the decision. I have said more than once in recent cases that our change of practice in no longer regarding previous decisions of this House is absolutely binding does not mean that whenever we think that a previous decision was wrong, we should reverse it. So it's not simply a case of seeing that the previous decision was incorrect. It says, in the general interest of certainty in law, we must be sure that there is some very good reason before we so act. So they declined to use the practice statement in that context, which was an interesting application, I think. Sticking with the criminal law, in R against Shiv Puri, we can see how the practice statement was used in the criminal law on attempts on Anderton against Ryan in overturning that. However, only a matter of a few months had lapsed, and so they stressed that there wasn't much injustice done in overturning that. So that would be an interesting case to read. In R against Jogi, there was a misinterpretation of earlier authorities for 30 years. They acknowledged the previous law had taken a wrong turn in that context. So that was in the context of joint responsibility, where a second participant was captured in the crime of the first principal offender, and so the rules around that changed, which you will certainly learn more of in criminal law, but it's important to note that they acknowledged that the law had taken a wrong turn there. And in the civil cases, I think an interesting case is British Railways Board against Harrington, which responded to social change and policy, and that really concerned a case regarding trespass, and landowners only had limited liability of trespass where somebody had injured themselves on their land. That if someone was trespassing on their land, there was only a limited liability. And in this particular case, what we had was a growth in the train system. There were train tracks running at the back of housing estates across suburbs, and children were playing on those fields by the train tracks. And British Railways Board held or argued that they shouldn't have to repair fences and to prevent children from going in there, quite simply because they only owed a limited liability to trespassers, and the House of Lords there were invited to use the practice statement. They did respond to that social change and could see that now there are certain liabilities, more liabilities, certainly more, they are limited liabilities, but certainly more liabilities towards someone who trespasses, particularly in the context of children. So what we saw in that particular case was a response to social change, the growth of the railways and train tracks running through suburbs. So we saw the law change to keep up to date with social change. And then similarly in Miliangos against George Frank Textiles, in the use of currencies and awarding damages in foreign currencies, that there were changes in that because there was quite simply a growth in international trade, and the law was seen to respond to that. So what we see in these cases are the way that the practice statement has been used, but in the context of a response to social change or in response to economic change or whatnot. When we move on to the Court of Appeal, there are two important questions concerning the Court of Appeal and the notion of stare decisis and the notion of judicial precedent. So first of all, to what extent is the Court of Appeal bound to follow the decisions of the House of Lords Supreme Court, and then to what extent is it bound to follow its own decisions? So we're looking at vertical precedent and horizontal precedent. So the first question then, in relation to vertical precedent, strictly speaking, the Court of Appeal should always follow the House of Lords. However, there have been two campaigns by Lord Denning to overcome this principle. One known as the Per Incurium campaign, and the other one is the Lapsed Rule campaign. And I would invite you to read quite extensively around those to see how Lord Denning challenged this particular principle. And per incurium means that a previous judgment has failed to pay attention to the relevant statutory provision or precedents, and for that, if you read Broome against Castle, and there was an argument there that perhaps the court should not follow the House of Lords where a decision has been made per incurium. And if you read that case, you will see that certainly there was resistance of that from the House of Lords, and this campaign by Denning was purely a campaign by Denning, and in numerous cases he was sort of put in his place as being a Court of Appeal judge rather than adopting rules to avoid the House of Lords decisions. And then we have the lapsed rule campaign, and that is if the reason for the rule of a previous House of Lords judgment had disappeared, should a precedent be followed, even though the whole basis of this precedent has disappeared. And in that Schwarzmeyer case was again involving currency being awarded, damages being awarded in foreign currency rather than in sterling. So those are two particular campaigns you might want to look at in relation to the way that the Court of Appeal should follow or should still follow the House of Lords decision. And then horizontal precedent, that was held. There are exceptions in Young against Bristol City Aeroplane, and again these are exceptions, these are not rules. So the rule is that the Court of Appeal is bound to follow its own decisions, except it can choose between conflicting decisions. It was not bound by its previous decision, or it is not bound where its previous decision has been overruled either expressly or impliedly by the Supreme Court, and nor was it bound where the previous decision was found to be made per incurium in that context. But it has to be expressly stated by or impliedly stated by the Supreme Court. It applies where there is ignorance of the authority that would have been binding on the court, and that ignorance led to faulty reasoning. So that is in the context of its own decision rather than the per incurium context, as we previously looked at in Denning in relation to the House of Lords. So what we want to consider next is the impact of the Human Rights Act. How does this apply? And what we want to look at here is section 2.1. The important point to note is as a court or tribunal determining a question which has arisen in connection with a convention right must take into account any judgment, and it goes on, any judgment, decision, etc. of the European Court of Human Rights. And the real question is, what does this phrase take into account means? Does this really mean, and there was a lot of uncertainty at the time it came into force, does it mean that the judiciary no longer apply precedent of the previous cases, that by taking into account decisions at the European Court of Human Rights, that does it essentially mean that they should follow in the context of a precedent, in the context of a ratio, should they follow the European Court of Human Rights? Or does taking into account just simply mean examine it, we've considered it, we've took it into account and we'll reject it? What we see in the last 20 years or so is that there has been an evolution and a change in what this taking into account means, and there is an element of discretion, or there has been, in relation to taking into account. And certainly right at the very beginning it was considered that taking into account did mean following precedent, but this changed in later years. So it was interpreted in Barclays Bank case to mean that lawyers had to bring to the court's attention all the relevant case law of the European Court of Human Rights, so in order for them to examine it. And then in R, on the application of Alconbury Developments case, it actually stated there the court should follow any clear and constant jurisprudence of the European Court of Human Rights. So it was almost as if now we have another court that the court should follow. So that was the approach that was adopted. Particular approach in that is that the Court of Human Rights may well apply a rule in the context of the jurisdiction of the particular state that it's looking at. So let's take by way of example, Italy may bring a case concerning a context of Italy, and using what's known as the margin of appreciation, the judiciary can adopt an approach of interpretation of a statute in the context of their culture, and so judges needed to recognise this as years went on, that in using the margin of appreciation doctrine, that the judiciary can adopt an approach of moving actually away from some of these decisions and applying them in the context of the United Kingdom. So I would certainly invite you to examine what the margin of appreciation means in these contexts. In the Ulla case, it says the duty of the National Court is to keep pace with the Strasbourg jurisprudence as it evolves over time. It says no more, but certainly no less. So it must keep pace. But what we see is that the context of this has changed. There has been a recognition that some cases may not apply, considering the domestic context. So by way of example, Horncastle used the margin of appreciation, which was on the context of, or on the question of the use of hearsay evidence. And hearsay evidence is essentially when someone hears something else about a crime, who's committed a crime, to how much can that hearsay evidence be used. And there are specific rules, quite very, very, very tight rules in England and Wales in that context. And on the question of whether it breached a right to a fair trial, on that the courts used the margin of appreciation and arguably moved away and departed from the evolution of the European Court of Human Rights on the matter. And in that context, they use the margin of appreciation to say that the domestic context just doesn't apply in the same way. However, they have taken into account the judgment, they've just simply not applied it. The court declined to follow a decision in the Grand Chamber in El Khawaja against the UK, which held that Article 6 requires as an absolute rule no conviction can be based solely or to a decisive extent on hearsay evidence. So following this line again, and it was interesting, if you look at Lord Phillips' speech in that case, have a look at that. He said the Strasbourg Court quite simply failed to appreciate the domestic process of the United Kingdom, and so the Supreme Court declined to follow that particular ruling. So this culminated in Manchester City Council against Pinnock, and in there Lord Neuberger stated, he says the court is not bound to follow every decision of the European Court. Not only would it be impractical to do so, it would sometimes be inappropriate, as it would destroy the ability of the court to engage in a constructive dialogue with the European Court, which is of value to the development of convention law. Of course, we should usually follow a clear and constant line of decisions by the European Court, but we are not actually bound to do so. So it's not got the element of precedent in the way that precedent works on the domestic scale, so it's not bound to do so, to follow it, but however they would usually follow those clear and consistent lines. He says, as Lord Mance pointed out in Doherty, it requires, Section 2 requires our courts to take into account European Court decisions, but not necessarily follow them. And what we see in more later cases is there has been a to-in and fro-in of what this taking into account means, and I would invite you to look at those cases to see where we are now, and to see how the court has perhaps moved to more of a following of the European Convention of Human Rights, the European Court of Human Rights. However, it doesn't necessarily go as far as to say that the court is bound to follow a particular decision. So what you need to really think about in the context of this precedent is what impact does Section 2.1 have? What impact has taken into account meant, and to look at the cases in the context of that to see how the doctrine of judicial precedent has been developed and been impacted by the Human Rights Act. So by way of summary, we've looked at what judicial precedent means. We've looked at elements of judicial precedent. We've looked at judicial precedent in particular, the Supreme Court and the House of Lords was, and also the Court of Appeal. And then we're making an evaluation on the impact of the Human Rights Act on judicial precedent. So our final thought we'll leave with the famous Oliver Wendell Holmes, that says the life of the law has not been logic, it has been experience. the felt necessities of the time, the prevalent moral and political theories, intuitions of public policy, avowed or unconscious, even the prejudices which judges share with their fellow men, have had a good deal more to do with the syllogism in determining the rules by which men should be governed. The law embodies the story of a nation's development through many centuries, and it cannot be dealt with as if it contained only the axioms and corollaries of a book in mathematics. In order to know what it is, we must know what it has been and what it tends to become.